Many extraordinary people possessing many remarkable, radiant achievements misread their own EB-1A case. And I want to be careful with that word misread. I do not mean that they lack a certain luster. In fact, they are extraordinary in the ordinary English sense of the word. Brilliant, they are. Brilliant researchers, artists, founders, scientists, engineers, people with curriculums vitae that briefly embarrass nearly all of LinkedIn. But immigration law is not asking an ordinary English question. And that is where the trouble begins. People, unguided by a lawyer, often think their case is stronger than USCIS will think it is. Then they file in high spirits, only to find themselves a couple months later staring at a denial letter that is assembled by a bureaucrat offering up a half-baked, prefabricated analysis of the case it took them so long to build. This happens frequently. Denials, they happen frequently. In Q4 fiscal year 2025, 47% of EB-1A cases resulted in denials. I see them. Sometimes a pro se petitioner will contact me after things have gone awry. I'm sympathetic because EB-1A self-assessment is difficult because it requires a kind of expertise most accomplished people have never had the need or occasion to develop. When self-assessment goes wrong, it is frequently due to one of three reasons. The first is structural. The standard USCIS applies in practice is often harsher than the standard people read in the written, published USCIS guidance. That is, the standard USCIS actually applies is harsher than the standard they are supposed to apply. I want that to sink in for a second. Okay. The second reason is cognitive. Self-appraisal is notoriously unreliable. People generally either cannot or will not see themselves as USCIS sees them. This is a big one. The third is technical. Extraordinary ability, I'm going to put that in quotes, extraordinary ability means something far more specific than most people realize. The structural layer, let's start there. The people who even consider an EB-1A are almost always remarkably high achievers. And that kind of achievement, it naturally breeds confidence. A completely justified confidence, I should add. If you spent a decade or two solving brutal, complex problems, your instincts inside of your own field are probably excellent, masterful even. But that is exactly where the trap springs. Immigration law is its own domain. It has its own rules, its own patterns, its own strange ecosystem of evidence, of evidentiary expectations. General analytical brilliance does not automatically transfer into immigration self-assessment competence because brilliant folks approach EB-1A self-assessment with the same confidence they bring to their actual profession. They face problems. And without a lawyer present, nobody interrupts them until the request for evidence arrives, which admittedly is a fairly aggressive form of feedback. AI tools make this worse. ChatGPT, Claude, Gemini. These tools often sound extremely confident evaluating EB-1A cases. Unfortunately, sounding confident and being correct are different activities. Anyway, the AI confidence is only part of the problem. The deeper problem, it's not AI. It's the documents that AI is reading from, or the documents that you read from. You see, would-be petitioners, and maybe the AI tools they consult as well, they operate on a reasonable assumption that USCIS adjudicators apply the rules USCIS publishes. The policy manual exists. It is publicly available. It describes how cases must be evaluated. Read it carefully, the thinking goes, and you can evaluate your own case. This thinking is faulty. However, it is hard to understand that without seeing, over the course of years, RFEs, denials, appeals, without having enough data. The standards often being applied by adjudicators are harsher historical standards, which deviate sometimes significantly from what the agency has publicly committed to, from what the agency must, back to that word, must do. I mean, this bothers me as an American. As a lawyer, I'm professionally accustomed to it. Agencies drift from their guidance and lawyers have to deal with it. We have to correct course or appeal, while a government that publishes a standard and then quietly applies a different standard is not a government operating fairly. It is sometimes how the US government behaves. Here's a concrete example. The policy manual addresses the judging criterion directly. The published guidance, which you can pull up on the USCIS website right now, says participating in the judging of the work of others in the same or allied field of specialization alone, regardless of the circumstances, should satisfy the regulatory criteria in the first step of the analysis. I'm not going to go over what all of that means, but I want to bring your attention to the part that says regardless of the circumstances. Because now you get language in RFEs that go something like, the record does not establish that the petitioner's judging activities were at a level commensurate with extraordinary ability. That is not what the policy manual requires. It is not a clarification of the policy manual. It is a different test applied without amendment to the guidance to the policy manual and without any announcement that the agency intends to apply it. The petitioner working honestly through their case, even through assessing whether they have a case to make, and using the published guidance to do that. They have no reason to anticipate the unstated requirement. They evaluate their case against the rule that they can see. Then they get adjudicated under a rule that they cannot see. This gets at the structural reason self-assessment often fails. Not because the petitioner misread the policy manual, because they don't have access to all the rules by which they may be judged. The cognitive layer, the psychology of self-assessment. It's hard to be neutral about your own history. A lot of people just can't be. Every accomplishment in your background or in your potential case is emotionally loaded, sticky with effort, sticky with memory, sticky with the years it took to produce. A publication that took 3 years, survived 3 rounds of peer review, destroyed your sleep schedule, destroyed your morning routine, and required you to run 2 additional experiments because reviewer 2 was not satisfied. That does not feel like Exhibit 14. A piece in your case, just a piece, which together with other pieces might establish that you are among the small percentage at the top of your field, or that you have sustained national or international acclaim, or just that you meet criterion 6, the evidence of your authorship of scholarly articles and professional publications criterion. The publication feels more important to you because to you it is more important. But USCIS is an experiential effort. USCIS doesn't know the backstory. Your adjudicator does not know you rewrote the paper 11 times while surviving on coffee and insecurity. They may see and take in journal name, citation count, publication date, topic, co-authors, things like that, and maybe a little else. And that creates a painful gap because the EB-1A legal assessment is external and cold and comparative. USCIS is asking, where does this person sit in the distribution of similar professionals? USCIS is not asking, how hard did this person work? Those are completely different questions. And then there's another problem. You unconsciously fill evidentiary gaps with your own knowledge. If you've worked in your field for 10 years, you know things about, for instance, your reputation that never make it onto paper. You know the conference conversations, the informal respect, the quiet influence, the people who know your work without citing it formally. So when you evaluate your own case, you may read all of that invisible context into the record. The adjudicator won't. The adjudicator only sees what survived translation into evidence. You are reading a case with memories attached to it, or a sense of standing attached to it. USCIS will not read it similarly. Deep specialization creates another trap. Experts see nuance. You, maybe a leading researcher, understand the elegance of your solution or the innovativeness of your methodology or the sophistication of a technical contribution. That's natural. But USCIS is not asking, is this sophisticated work? USCIS is asking, how does this person, you, compare statistically to other people doing similar work? How has this work impacted others in the field? Questions like that. Those are different questions. That means internal respect within a subfield does not always translate cleanly into immigration evidence. Someone can be deeply admired inside a specialty and still present weak comparative evidence, external evidence. Not because their work lacks value, because immigration law speaks the language of distributions, metrics, and corroboration, not the language of intellectual beauty, which is unfortunate because intellectual beauty is much more pleasant. Now, briefly, the technical issue. To the uninitiated, extraordinary ability sounds like a vague compliment. It is not. In fact, it can be aggressively quantifiable. The regulation requires evidence that the petitioner is among the small percentage at the very top of their field. That is a measurement, a position in a distribution. And distributions, as any statistician will tell you with a certain dry satisfaction, are things described by numbers. Some fields make this obvious. In sports, you can quantify almost anything. Championships, rankings, statistical records, the size of contracts. In research, citations, H-indexes, journal impact factors, grant funding, the rate at which other researchers adopt your methodology. But a trap is to assume that fields without obvious metrics are exempt from this analysis. They are not. Take art. Nobody can put a number on the beauty or the meaning of a great painting. True. But you can quantify much that surrounds the canvas. The number of solo exhibitions that the artist has had, the number of museums that have collected the artist's work, the number of articles in the most prominent art publications about the artist, the sale prices of the artist's works, the number of major awards won, the number of times the artist has been invited to judge the work of others. Each of those is a number. Each can be compared against other relevant individuals in the field, against the field at large, against the small elite group at the top of the field. The same exercise works in literature, translations into other languages, sales figures, awards, inclusion in canonical anthologies, adoption in major university curricula, major reviews in the most prominent literary publications. It works in music, recordings released through significant labels, concerts at venues of meaningful prestige, sales and streaming figures, critical reception in the most respected publications, the number of major awards won. It works almost everywhere. What petitioners underestimate is how far the quantifiability principle reaches. Their internal experience of their field, the texture, the difficulty, the artistry, the meaning, is not what USCIS will evaluate. USCIS will evaluate the measurable shadow of the work. And then those measurements will have to be compared. Treating extraordinary ability, or among the small percentage at the top of the field, as loose qualitative sentiments rather than comparative claims leads to a wobbly self-assessment. So yes, there are structural hurdles and cognitive hurdles and technical hurdles that make self-evaluation, self-assessment hard and unreliable. So I'd encourage you to reach out to a lawyer for your entire case, but definitely the start of the case. Talk to one of us, see how we can help, see our opinion on your prospects. Especially now, when denial rates are climbing toward levels that should concern anyone paying attention. The strongest EB-1A petitions are not necessarily filed by the most accomplished people. They are filed by people who understood early enough to act on it that this area of immigration requires a specific expertise, and people who, knowing that, decided to seek out help. If you're at that point when you're ready to move forward, potentially at least, with an EB-1A case, know that my law firm handles these cases all the time. Reach out to us. Contact information is in the description. If this video was useful, subscribe, because there will be more videos like this on the way.